Right, Ed, over to you.
Thank you, and a very warm welcome to everyone to our first live LinkedIn workshop on the subject of guiding rural businesses and landowning families through the inheritance tax changes that were announced in October 2024. We've done this workshop in person in front of clients and professionals 3 times, so we thought we'd have a go on a live platform. We're delighted to be able to do this. I am the managing partner of Barlow. My name's Ed Whittington. I come from a farming and landowning family and practiced before I became the managing partner of Barlow in rural property, helping families navigate through the complexities of succession many times and still fulfill the role of a trustee for lots of families. So I live and breathe this subject personally, as well as for people that I look after in a professional capacity. And delighted to be joined by my colleagues, and I'll just introduce them in order. I'll firstly be introducing you, once I've done my introduction, to Sonia, who is a specialist in wills, tax and trusts and deals with the succession side of that. And then Sarah Jordan, who is a rural property lawyer, will share her insights on a more kind of practical aspect to gearing up for these changes next year. And finally, David is joining us. He's a specialist in the more kind of corporate documents, partnership agreements and shareholders agreements that we often see, which also need to be carefully considered in the run up to these changes. But I'm going to start just by sharing some reflections on the announcements in October and all of the work that some of the bodies representing the landowners have been working on. Obviously, this has been a huge subject and actually a very emotional one, because we've seen the farmers take to the roads in protest, driving to London. I personally know people who've been impacted by these impending changes, and also working on live matters where we're making changes to help families navigate the situation. And we'll all potentially be mentioning the prospect of death in a family, because we're talking about inheritance tax in the main, although we've also got other taxes such as capital gains tax to consider. But inheritance tax is clearly levied on death, and although we might talk about that in a slightly kind of cold way when we're dealing with planning, I didn't want to gloss over just how emotional a death in the family can be. So any mention of that kind of thing comes with the sensitivity towards how difficult it is for families to think about these sorts of changes. So Robin, if I could have the first slide. What I thought I'd do just to set the scene really is as we're in Hampshire, as we talk, I've used a typical Hampshire farm and just painted an extremely simple situation, and actually based half on truth, half on not truth, because there are some elderly couples like Bob and Belinda around, and is, as I say, based on a situation that I know of, but I've put in a whole load of fictional stuff, so could not possibly be recognised, and kept it very simple. And this is just to explain just how profound these changes are. I'm conscious that the audience may well be highly sophisticated professionals, all the way to people who are only looking at this for the first time. So forgive those very highly sophisticated professionals, you have to forgive me that this is a simple situation. We've got Bob and Belinda in their 90s, own a lovely, beautiful Hampshire farm. They have one son, and certainly in Hampshire, this sort of setup worth a huge amount of money, 9.5 million. I've put the overall value at. As I say, a beautiful 600-acre farm, a proper Georgian farmhouse where they've run the farm for decades. One commercially let building, 3 cottages, and Billy, who is a committed farmer as well and employed on the farm. And what I've done is just to illustrate the problem that what these changes are going to bring about. Just going to talk you through a couple of scenarios which make it incredibly stark, and also talk about, sadly, ushering off Bob and Belinda in a different set of sequences. And I obviously do that. I don't do that lightly. So in the first scenario, Bob dies shortly this summer, passes everything to Belinda. There's obviously no inheritance tax when it goes from Bob to Belinda. Belinda takes it on. Billy's still at home. He's going to be running the farm, and the farm makes a small profit. Some years, frankly, a loss, but as you can say, 15 to 45,000 per annum. Next slide. Now, in my 2 scenarios, really sadly, Belinda doesn't last that much longer. She struggles on into the winter of 25, and later this year, she sadly dies. And in that scenario, if that happens in this situation, although they have an asset or assets worth 9.5 million, there won't be any inheritance tax. What we set up there is what's called the perfect Balfour situation. And in some of our workshops, I always asked, do people understand what a Balfour situation is? And in all 3 workshops, we had quite a few hands going up, saying effectively they had absolutely no clue what a Balfour situation is. So I'll just really quickly explain that. Balfour was the name of a case, in fact, the name of a family, and they had a mixture of trading assets, such as the land and farming, all the farming assets, and trading assets, if they qualify for business property relief, have always been, we've been able to hand those down free of tax. Unlike investment assets, such as things like cottages, which you just let out and you just receive the money, they're not deemed to be trading assets by the government. And if you do nothing with them other than let them out, you've got to pay the inheritance tax, which is the 40% over the nil rate band. Now, obviously, a lot of these farming landowning families have cottages and other assets such as commercial property, which are rented out, and on the face of it would not qualify for business property relief, so you'd have to pay IHT. However, there is a way in which you can set your affairs up, and many families have done this over decades, whereby you can mix your let properties, commercial or residential, in with your trading assets, your farm, in a partnership, put them all in, and as long as, roughly speaking, the investment assets are effectively worth less than 50%, and there are various tests which I won't get into, but the upshot of it is you can effectively mix your rented properties in with your trading properties, and if you get the mix right, i.e. there isn't too much of the let property, the whole thing will be regarded as a trading entity. And in this situation, we've got 3 cottages, 1 commercially let building, and a reasonable size arable farm. And in that sort of situation, the whole thing would have been able to qualify for BPR. Therefore, Belinda dies this winter, very sad. Billy takes on the farm, has no tax to pay. In my second scenario, Belinda survives a little bit longer, not much longer, probably maybe only 6 months, and dies the following summer, next summer. And I've just set out how profoundly different that situation would be for this family. So you've got the 9.5 million, that's what the farm is overall worth. In fact, in this situation, you now have to be putting in various elements such as stock and machinery, so it might even be worth a bit more than that. But I kept it really simple. And we take off the new allowance. I've deliberately only given them one set of the 1 million. This is the new allowance. So we brought that down to 8.5 million. And now, of course, going forward, the remaining 50% will be subject to APR. Remaining 50% qualifies for APR, BPR, less than nil rate band, and there's 2 nil rate bands there because we've got both Bob and Belinda's. Ultimately, after the new release, we'll be down to 3.6 million at 40%, and that would be an IHT liability of 1.4 million. So you can see the staggering difference between the two situations just with a 6-month difference in the timing of Belinda's death. So next slide. And what I'm going to do now is I'm going to hand you over to Sonia, who's who's a genuine expert in the legalities of what I've just talked you through, and bring to life some of the nuances that we've been hearing about in the press, particularly in terms of things like residence nil rate band and the 3 million figure that we keep hearing about. But hopefully that first example is incredibly simple, but you can imagine having a 1.4 million pound tax liability on a farm that makes between 15 and 45,000 a year is going to be completely unsustainable for Billy, even if he's got to pay that over 10 years. I would say that's probably an unsustainable situation, and Billy will need to sell the farm or at least significant assets to fund that. Anyway, Sonia, if you're there, I'll hand over to you.
Right, can you hear me now? Oh, hello. Right, hopefully you can hear me now. Apologies for slight technical glitch. I did start off by saying that this is the first for me on a presentation doing LinkedIn, and obviously I was the one jinxed with no sound. I'm still getting a message here saying still nothing. Can you hear me, Ed?
Yes.
Lovely. Okay. So what Ed was saying is that we're obviously moving from a situation where we had all been planning for both our farming communities and business communities on the assumption that, generally speaking, agricultural and or business property relief would be available at a rate of 100%. And so the proposed changes, which it doesn't seem likely the government will now deviate from, have been somewhat of a shock. The difficulty for us experts is that the devil is very much going to be in the detail, and we don't yet have the draft legislation. However, since the budget announcements, we have had a little bit more information, which has been quite helpful, and the open consultation that is in process at the moment will be closing this week, and so hopefully some draft legislation will follow as soon as possible, although the cynic in me thinks that probably it will come much, much later in the year, because why give us lots of time to think things through. One of the things that the government has confirmed in the additional information that they have given us is that, alarmingly, this £1 million allowance is not going to be transferable between spouses and civil partners. So whereas the ordinary nil rate band and the residence nil rate band is transferable, the agricultural business property relief allowance will not be. Just to clarify, so what will happen is that the first £1 million of qualifying assets will be given the agricultural business property relief at a rate of 100%, and then any resulting balance will be, as Ed just explained, taxed at 50%. So you do still have a considerable relief, but as the Bob and Belinda example showed, it really is going to make a huge difference between having no tax to pay and actually sort of, potentially in the millions. Now, one of the headlines following the budget proposal was, don't panic, everyone. There is actually still going to be effectively £3 million of relief. And unfortunately, this is slightly misleading because that £3 million relief actually includes and assumes that the full residence nil rate band will apply. I'm hoping that you can now see a slide so that we're entitled Mum and Dad. Each of the individuals, let's assume, are entitled to the £1 million relief. Let's also assume that they have done some lifetime planning so that actually they will utilise both of those £1 million allowances as opposed to missing out on one, just as Bob and Belinda did. You've then got your £325,000 ordinary nil rate band, which I think we're all largely familiar with. And then we have this additional residence nil rate band of £175,000 per person, but only provided that certain qualifying conditions are met. It is an extremely complicated piece of legislation. But the reason I don't intend to go into it in very much detail for the purposes of this presentation is that actually largely it simply isn't going to apply. And the reason for that is because the residence nil rate band, there is a taper threshold that applies. So for individuals with an estate worth more than £2 million, for every £2 that you exceed that taper threshold, the relief is reduced by £1. So taking Bob and Belinda's estate as the example, the taper threshold exhausts and completely diminishes the residence nil rate band before we even get started. So that £3 million allowance that was headline is actually quite misleading. One thing that is good news is that something that a lot of us will have been doing in recent years is investing in the AIM, the alternative investment market, on the basis that if you hold shares on AIM for 2 years prior to your death, it will then qualify for business property relief. And surprisingly, what the most recent guidance suggests is that if you do have an AIM portfolio, the value of that AIM portfolio is not going to eat into your £1 million allowance. However, you will only get 50% business property relief on those portfolios. So it's only a slight concession, but it is one that is relevant nevertheless. Now, in response to the proposed changes, we have had a lot of clients who have been discussing with us wanting to pass on business assets, farm assets now to the next generation, with a view to trying to mitigate the Bob and Belinda scenario that Ed went through. Now, one of the things that has been relevant for many years now are the rules regarding potentially exempt transfers. So again, this is something, because it has been around for so long, most of us are familiar with. It's that classic 7-year rule. I give something away, I survive by a period of 7 years, and on the face of it, the value of what I have given should fall outside of my estate for inheritance tax purposes. The question is, what happens if I were unfortunate and died within that 7-year period? Now, the budget announcements were 30th of October last year, 2024. If you had made a potentially exempt transfer before that date, the old regime will continue to apply. So if I've given away my farm or part of my farm and I don't survive by the 7-year period, at my death, the old regime will apply. So the agricultural and business property reliefs at 100% should still apply to that failed potentially exempt transfer. Unfortunately, the government foresaw that, having made the announcement that they did on the 30th of October last year, that people may then feel that, well, actually, let's trigger some potentially exempt transfers and take advantage of the old regime. Well, unfortunately, that won't work. So what has been said is that if you make a potentially exempt transfer on or after the 30th of October 2024, the new regime will apply should you be unfortunate enough to die within that 7-year period. So if I give away, several acres or whatever of a farm, I die within that 7-year period, the value of what I've given will be set against my £1 million allowance before then taking into account what the remainder of my estate is worth on death. We'll also, most of us, be familiar with the fact that there are some taperings. So if you survive your potentially exempt transfer by 3 years or more, the ultimate inheritance tax liability may be reduced slightly further, but it really is that 7-year rule that is most important. And of course, obviously for a lot of our clients, friends and family, that 7-year is potentially rather a big ask, and of course that is causing a lot of stress to the community as a whole. Something else that really does need to be given some quite detailed thought is that if you make a potentially exempt transfer, you have to be very careful to avoid the rules against gifts with reservation of benefit. So the classic way to explain this is, I give my house to my daughter, but actually I'd quite like to carry on living there, please. If that's what I do, and I don't pay a commercial rent for that privilege, at my death, even though my house belongs to my daughter, it will be taxed for inheritance tax purposes as if it still belonged to me. So in the context of a business, farm, whatever nature of business you have, if you are giving away parts, it's going to be really important to think through how matters are structured if you give something away, but in some way you are going to continue to reap a reward. And that's where David and my other corporate colleagues come into their own, because you'll be looking at how businesses are structured and so on and so forth. Now, when it's just simply land or property that you're giving away, it may also be appropriate, rather than just thinking about paying a commercial rent to avoid the gift with reservation of benefit, is to look at an alternative tax, which is the pre-owned asset tax. And the pre-owned asset tax regime is a way of the government levying an inheritance tax equivalent, but it's paid during your lifetime, collected through the self-assessment income tax regime. And if you are paying pre-owned asset tax during your lifetime, it cannot be that you are then taxed for inheritance tax again on your death. I'm deliberately describing that in a very overly simplified fashion because, again, it is a very complicated tax. And this is probably where it's most relevant to point out that, you know, although, yes, okay, I'm an expert in my field, I'm by no means the only one. And so when you're looking at things like pre-owned asset tax, gifts with reservation of benefits, you're usually wanting to work with other professional advisors within your sector. So pre-owned asset tax, accountants, you're going to be wanting to work with the individual's accountant. You're going to be wanting to perhaps involve their land agents. You're going to want to be speaking to their financial and pension advisors because, of course, pensions are also being reviewed and brought into the inheritance tax regime. Now, as I said earlier, when we're talking about things like potentially exempt transfers, our focus is on inheritance tax, but of course there are potentially capital gains tax implications if we choose to make a disposal during our lifetimes. And again, this is where working with one's accountant is going to be important because we'll be looking at, do we think that we can get some holdover relief? So can we defer the capital gains tax liability? Do we need to be looking at creating some trusts in order to also benefit from that if we don't use it because it's a business asset? There are lots of little bits and pieces that people could be doing to try and mitigate their exposure. Now, here at Barlow, what we have done is in order to really sort of try and help clients identify the sort of immediacy or urgency with which they need to approach this, is we've developed a sort of traffic light system. And really, for those that are, 50 and under, chances are you're really in the green traffic light area, whereby, actually just keep going as you are for now. Don't make any knee-jerk reactions. Keep abreast of what the legislative changes are. Get your house in order, but you will be able to start to do things over a passage of time, taking advantage of your 7-year rule, your potentially exempt transfers, and so on and so forth. However, the older we get, the more urgent perhaps things become. And so for those who are sort of, 80 plus, you're sort of more in the sort of red urgent category. And we would be very happy to speak to anyone to help guide them through the changes that we are anticipating. So I think, unless anyone's got any questions for me, I will hand you back to Ed.
Thank you, Sonia. That was incredibly helpful run through of the more nuanced aspects of the things that we need to be thinking about, including, of course, that it's never simple. We can't just give assets away. We've got to be mindful of reserving the benefit and working out ways we can do that in a sensible way, which complies with the rules, and the big one, capital gains tax, and exploring whether or not we can find ways to defer that tax through holdover relief and other measures such as that. And the big message there really is the absolute paramount importance of lawyers working with landowners, farmers, and the rest of the professional community, such as accountants, tax advisors, land agents on valuations. That'll be a big theme coming out of our workshop today, which Sarah will build on as well when she talks about more of the practical elements of what you ought to be considering around the actual property and the ownership of the property right now in the lead up to the changes. So on that note, I'll hand over to my colleague Sarah.
Okay, hello, can you hear me before I get going? That's all
Yeah.
good? Yeah.
Okay.
This is our first LinkedIn live session, so it's a bit of a learning process for us as well, but we're thoroughly enjoying it here. So if I could have the next slide. Thank you. So what Ed and Sonia have touched on is the importance of collaborating with all trusted advisors. When it comes to this IHT planning, obviously there is a lot of clever tax planning that is going on, but as a group of professionals and the family business, the rural business, we've got to deliver on that tax planning, and that takes a group effort. It very much is going to be the family business, the rural business, the landowner, the agent, the accountant, the lawyers that specialize, like Sonia in the succession planning, like me in the property restructuring, and like David in the corporate restructuring, that will be needed to deliver on the tax planning by 5th of April next year. So we've not got long. And what I wanted to touch on today was some more practical points that you can take away from today's session to start looking into. Again, we haven't got long, so the sooner clients and their advisors start doing the points I'm going to run through, the more likely it is that we'll deliver on time for you. So if I could have the next slide, please. Thank you. So my background, I'm a property lawyer, so rural property, so I'm used to dealing with people's legal titles, how a property is legally owned, and there is often a mismatch between what we call the legal ownership and the beneficial ownership. So often um, the estate planners, the accountants, my corporate colleagues are dealing with the beneficial title. They've got partnership agreements, they've got declarations of trust setting out who potentially gets the benefit of land and businesses. But there's often a mismatch with what actually sits on the legal title with the land registry or on the title deeds if land remains unregistered. And this is a key thing to check before you start doing all your tax planning, to make sure that actually the legal title reflects who you think the ownership should sit with. That's the first port of call. Have a decent farm, a decent estate plan, understand where your registrations sit, who legally owns every part of the farm and the buildings, and make sure that you're well aware of where the legal titles sit. This kind of process often uncovers various discrepancies that need to be put right. So the sooner you understand where those discrepancies might be, the sooner we can put those right for you. On the property side, there's often, when it comes to large land owning titles, there's often land or buildings that still remain unregistered with the land registry. So it's important that first registrations are put through. These can easily be done if you've got the original title deeds for land or buildings, or we need to put together a sort of evidence portfolio, we call it, with statements of truth confirming your ownership if deeds are missing potentially. So that's really important. Understand who owns what. Organise your land, organise your property, and get that in order. The second thing that is really important to get underway are valuations. So you will be needing your valuers, your surveyors, your land agent to start getting those processes going. The valuations will be needed by the accountants, by Sonia, the estate planning teams, to sort out succession planning advice. And one of the things as a property lawyer, I'm trying to encourage accountants to include in their tax planning is a stamp duty land tax assessment if there's any debt, because if you leave that until the point it sort of reaches the property team, for example, it may be that the stamp duty land tax angle hasn't been picked up early on. So please, as accountants, consider any SDLT that might be due as part of the tax planning you're doing. When it comes to ownerships, often on your titles, there might be restrictions to third parties. So things like if you've got lending through a bank, there might be a bank charge. You'd need a bank's consent to do any transfers out of your title to another third party. So it's understanding as well what third party restrictions sit on your title, and whose consent we might need for potentially exempt transfers, as Sonia mentioned, transfers of whole, transfers of part. When it comes to the transfer deeds, as a property lawyer, there are two types of transfers we do. There's a transfer of whole, effectively. That's when you're dealing with a whole title. Those are relatively easy and quick to do because the title is what it is. We're transferring from one party to another party. Transfers of parts are more complex. That's a complex property deed. It requires some detailed drafting, some detailed discussions amongst the family relating to things like obligations and covenants that go on the title. You might want to sort of restrict land use in the future. So transfers of part do take longer. They are carving a portion of land and property out of a much wider title, so you also need a very decent land registry plan, a compliant plan. Again, agents are critical for that kind of thing. It's making sure it's all properly mapped. Access points are thought about, all that sort of thing. So you can see why we need such combined effort. It needs to, very much be a group discussion. I'm just looking through my list here. We've talked about the legal and beneficial title. As part of this process, it's often a very good time to review your wills. That goes obviously back to Sonia's team, but it's updating wills, it's updating LPAs, your lasting powers of attorney. It's making sure declarations of trust are drafted and all done at the same time as what the tax planner is effectively advising. So what the tax planner will probably do, depending on who you're using, you'll have a list of things that your lawyers need to do, and that will be the property restructure work, the corporate restructure work, any will updates and LP updates, and we'll all be working to the same sort of deadline, which will probably be the 5th of April at the latest next year, but earlier, a lot earlier if we can make that happen. Family discussions are hugely important. Ed's touched on this being a very sensitive subject. Families often struggle to talk about their succession planning and who will take on the farm. I think a slightly more practical bit of advice is for families to be as open and transparent as possible in terms of what they want. What's the vision for this business? Is there a particular child that wants to take it on? If they don't want to take it on and they don't want to face a potential IHT bill, that they might want to cash in and sell up. But if there is hunger for that farming business or that family business, then it's very much a strategic, professional advice approach as to how you can, or the next generation can afford that IHT bill. In our case studies case, that's Billy. How is he going to afford to pay that £1.4 million? There is the 10-year interest-free repayment for inheritance tax, but that's still a bill of 140k a year. So for a farm that is making between 15k and 45k a year, it's going to be very difficult for him, Billy, to do that without potentially selling off a portion of it. So that is what all this tax planning advice is around. It's trying to help that next generation take on the farm if that's what they want, or come up with a plan for selling if that's what the next generation wants. What I haven't touched on is corporate restructuring, because David is sat right next to me in our Gateway office here in Southampton, and he is perfectly primed to discuss partnership agreements that will be needed. Often these are not documented, and we find that as part of this process they need to be documented or updated, and he's an expert as well in company law, limited companies, LLPs, and all that will be required to deliver on the tax planning by next year. So I probably haven't covered everything you want. Please email me or ask questions in the LinkedIn feed here if you'd like to. We're always happy to hear from anyone that's been watching or listening to this. So thank you for your time. And I think we're going back to Ed, who will cover off anything that I've missed and then move on to David. Thank you.
Thank you, Sarah. And I don't think you've missed anything. There's a comprehensive list in front of you, so thank you for that slide. I think the big message from Sarah, which is absolutely right, is talk and talk some more, plan, and be organised, because if families are coming to lawyers with a few weeks to spare before the changes come in, it's going to be extremely difficult to put into effect those changes. So talk now, plan now, and be organised. And I think we just got our last contributor, so I'll hand you over to David to talk about more of the corporate side, where your partnership agreement is, whether you're a limited company, anything you should be thinking around corporate structure. So David, over to you.
Thank you very much, and it's a pleasure to be here speaking today about partnerships, particularly involving farms and farmers. So to start at the beginning, whether or not a partnership exists is a matter of fact, and parties cannot decide themselves that a partnership exists. It's actually governed by some very old legislation, the Partnerships Act 1890, which sets out that a partnership exists where a persons together carry on business with a view to a profit. So a lot of the farming businesses will actually fall within that definition of partnership. So that being said, it's therefore important that the rules governing the partnership are properly thought through and documented, because if they're not documented in the form of a partnership agreement, then the default position will be that the provision set out in the Partnership Act 1890 will apply, and that may not be what the partners actually want to be the case. It is possible to vary that position by a course of dealing, which means that actually if by the way in which the partners in practice operate the partnership, they deviate away from what the Partnership Act says, that can then become the default position. But it is always far better to have a written partnership agreement which properly considers and sets out the basis on which the partnership is to operate. And that's especially true for farming partnerships, because not only have you got the usual trading activities of the farm, but you've also got usually quite significant family assets which fall within the partnership and therefore need to be considered. And more properly, the income related from the trading activities and the basis on which the capital or the assets have been contributed to the partnership should be properly set out, because the default position is that the partners are entitled to the income and the capital equally, which may not be the intention between the parties. In addition, there are a number of other things that partners should properly cover off in any well-written partnership agreement, and they include things such as what happens upon a partner's retirement, as well as incapacity and also death. And you would want to agree that up front to ensure that there is an orderly and well thought through a handover of the farm to the next generation. And that is where you would also want to speak to Sonia and the team to make sure that from a tax perspective, that is properly thought through and structured in a way which is tax efficient. That would also include the way in which the partnership is valued and also any form of partner is actually paid out. Unfortunately, disputes also happen within partnership, even within a family partnership, and you would want a disputes clause that provides a mechanism allowing for any dispute to be resolved. One other point to consider in relation to a partnership is that partnership property is separate to personal property. And if there is not a written agreement, there can be a blurring of lines as to whether property should be properly treated as partnership property, or actually, if instead, it should be personal property. And so therefore, you would want any well-written agreement to properly set that out. In addition, farming partnerships can also be carried out by way of an incorporated entity. So it can be typically carried out within a company limited by shares or by guarantee. And if that is the case, you would want what is known as shareholders agreement, along with well-written articles of association. And they would cover the same sort of points as a partnership agreement, i.e. it would cover income, capital, and the basis on which shares can be transferred to other people. Moving back to an unincorporated partnership, though, where you have a partnership which hopefully is covered by a well-written partnership agreement, you may well be considering whether or not it is appropriate to move that unincorporated partnership to an incorporated entity. And there are a number of potential advantages to this. The first of which is that with a partnership, the partners are personally liable in respect to the debts and obligations of the partnership. That means that if a partnership is unable to cover its debts, then to the extent that there is not insurance in place or those debts cannot otherwise be covered, the partners will be personally liable. With an incorporated entity, such as a company limited by shares, actually that company is a legal person, and therefore it shields or protects the shareholders from being personally liable, other than the equity that's held within the business. The second reason why you might consider incorporating a partnership is in relation to the separation of the managers to the owners of the business. With a partnership, a partner may well carry one or both of those roles, yet still be deemed to be a partner. But with an incorporated entity, it is possible to separate those out so that you can have directors on the one hand who are involved with the management of the business and they do not own any of the business, and you can have separately shareholders who do own a proportion or all of the business. You can, of course, have individuals who are both directors and shareholders and therefore involved in both the management and the ownership of the business. A third potential advantage of incorporating your business is in relation to raising finance. And that is because it is more common for lending to be given to companies, and therefore you probably would find a larger number of lenders in the market who are willing to lend money to companies. And that is possibly in part due to the fact that with a company can offer fixed and floating charges, which a partnership cannot offer. So that makes it more attractive to lenders to lend money because they are given better protection by the way of security. A fourth potential advantage is in relation to the sale of the business, which has already been touched on within this LinkedIn session. And if in the future you are thinking of selling the partnership business, there are more options available to you if it sits within a limited company. And this is because you have a choice, which is often a tax-driven choice, as to whether or not the company itself sells the business and assets to the purchaser, or otherwise, alternatively, if the shares in the company are sold to the purchaser. And often purchasers are more used to buying shares in a company. And then finally, but perhaps most importantly, and going back to Sonia and her team, it's possible that there might be some sort of tax advantage to incorporating your business. And you should certainly get advice from Sonia and the team before undertaking any incorporation of your business. In relation to potential disadvantages of incorporation, there are a couple of main disadvantages. The first of which is that certain information will be on public record. So as a limited company, you will be obliged to register directors and shareholders, and therefore a certain amount of information will be on the public record. In addition, you will be under an obligation to file annual accounts, and therefore a degree of financial information will be on the public domain, and there is the inevitable cost to that, as well as filing confirmation statements annually, which adds to the administrative burden of operating through a limited company. So in terms of the steps which you would take in relation to the incorporation of a company, incorporation of your partnership business into a company, you would start by incorporating the company itself, and then you would start to draft what is known as an asset transfer agreement or a business purchase agreement. And that sets out the assets of the partnership which are to be transferred into the limited company. There are a number of considerations that need to be made when taking this step. The first is to consider any existing security. If there is an existing security provider, you need to carefully review the documentation and understand what restrictions or what consents you need from the lender in order to potentially move the debt into the new incorporated company and have the newly incorporated company provide new security. In addition, you'll need to consider whether or not you have any employees within the partnership. And if you do, then the transfer and undertakings protection of employment regulations are likely to apply. And there is a specific process that must be followed to adhere to those regulations to ensure that the employees properly transfer to the new entity. And we work closely with our employment team here at Barlow to ensure that those regulations are properly adhered to in relation to any asset transfer. Another consideration which you need to make in relation to the incorporation of your business is any key customer or supplier contracts. And in particular, what you'd be looking for are any change of control clauses or any other provisions which relate to the assignment or transfer of the clause. What that means is there may well be a provision within your contract which either says you cannot transfer that agreement to a third party, whether a newly incorporated company, as we are potentially intending here, or otherwise, without the other party's consent. So you'd need to do that analysis before undertaking the asset transfer to make sure that any of those key contracts and supplier contracts can properly be transferred. And the last thing to think about in relation to the transfer of your business is just the basis on which the new company will pay for the assets, whether or not they'll be gifted, whether or not they'll be transferred and left, the consideration being left as a debt or some other mechanism. And again, that may well be tax driven, and you should speak to Sonia and the team to ensure that that is properly considered and thought through. Upon completion of the asset transfer, you should also then consider putting a shareholders agreement and articles of association in place, which will properly set out the rules and regulations in relation to the governance of the company. And that is it from me. Thank you very much for listening. I'm going to hand back to Ed now.
Yeah, thanks so much, David. That was really helpful. And in fact, Sarah's just asked to speak momentarily before I wrap up. So, Sarah, you just wanted to add something. I'll hand over to you.
Okay, hi. Yep, back to me. I just wanted, again, we're talking about an incredibly sensitive subject here, and I wanted, what we have been doing in all our workshops is highlighting the Farm Well campaign. So I think all of us in the rural sector owe a duty to anyone we work with, anyone we are looking after, neighbours, landowners. If anyone is struggling, there is a charity called the Farming Community Network that is available to support anyone that is struggling with potentially the IHT consequences. Going back to our case study, when you think about Belinda, so Bob has obviously passed away. Billy is looking to succeed and take on the family business. The consequences for Belinda of understanding how the date of her death could affect the IHT bill being passed on to Billy is enormous. So it's this sort of scenario that we need to sort of just keep a watchful eye out and look to protect. So there is this independent charity called the Farming Community Network. They are running a campaign called the farmwell.org.uk campaign, so you can find out more information there. They help across the board with rural sector issues, but obviously at this moment in time, IHT planning is picking up quite some momentum. So there will be somebody on the end of a phone if anybody is particularly needed. That's all from me. Thank you. Bye-bye.
Thank you, Sarah. No, I couldn't agree more. It's a highly emotional subject, and I can think of many families who are puzzling and worried about the future. And again, just coming back to my example, thinking about the elderly couple in their 90s, Billy's probably 60 plus, almost certainly has children, has invested his entire life's work into the farm, quite possibly has a child who has been planning to do the same, and they would be almost certainly staring down the prospect of selling that farm. And I think that's why we've seen such an emotional reaction to the tax changes. So just to wrap up as briefly as I possibly can, going through the considerations, obviously there are things that can be done, and that would really depend hugely on people's circumstances. Mainly probably due to things around the way you hold the land, all of the sorts of things that we've been hearing about. But actually age is going to be a hugely determining factor. And we'd say anyone potentially over the age of 70 ought to be thinking extremely carefully and planning some sort of action, talking to their advisors. Potentially if you're in your 50s and 60s, you've got a little bit more time, and could be slightly more mindful of using some of the relief, such as the 7-year rule, that kind of thing. So all sorts of opportunities, but possibly not the need to absolutely rush in. Important to talk with your family. And then for a farmer or landowner who's younger, 40s, maybe early 50s, certainly does have more time and can think things through. And one thing I'd mention there particularly is looking into life insurance, because ultimately, if the risk is less, i.e. you're not likely to die in the immediate future unless something catastrophic is going to happen, life insurance might well be affordable and a really, really extremely sensible thing for your family to have in place. So there's a little bit of a traffic light system there, depending on age, but then all these other things that have been talked about. David highlighting the way in which you hold the land will depend on potentially whether you can borrow money. So the banks need to be talked to, tax advisors, lawyers, land agents. We need to understand the value of assets. So getting on the front foot, initiating conversations within the family with professional advisors as soon as possible, because if things are to be done, it will take time to make those changes, and if it's left too late, then it may not actually be possible to process the changes. So I don't have a huge amount more to say other than to thank everyone for listening. I apologize because I'm at home and every dog decided to bark. The cockerel was crowing. There were about 5 helicopters that came over, so I hope you didn't pick that up. And thank you for your forbearance through the LinkedIn live format, in particular with Sonia, who we didn't get wired up immediately, but on the whole, it's gone smoothly since then. Thank you very much for listening. And if we can be of any help, please do get in touch. And that's all from us. So have we got time for questions? I think we'll probably leave it there and ask people to get in touch if they need us. Thank you.